Good evening, everyone. Welcome to our virtual transition booster tonight called Trusts and Stable Accounts. While Lori is letting people in from the waiting room, I wanted to welcome you to today's webinar. We're here to talk about trusts and stable accounts and provide information for families and caregivers who have youth with special needs and professionals who support them. My name is Amy Clausen, and I am the Northern Ohio Family Specialist at Ohio Family to Family. We are housed at the University of Cincinnati Center for Excellence in Developmental Disabilities that sits within Cincinnati Children's Hospital Medical Center. First, we'd like to thank you for joining us. Before we begin with the actual presentation, I would like to address a few logistical details, which I'm sure most of you are used to by now. All participants' video functions will be turned off. Your microphones will be muted as well. And we ask that you please enter your questions in the chat box. We are expecting a large number of people tonight, so we appreciate your help. We are recording this webinar tonight, and the recording will be available on Ohio Family to Family's website in a few days. We also have an evaluation survey to share at the end of the training, and we really appreciate your feedback on this webinar and really, most importantly, suggestions for future transition booster topics. I couldn't do this without my partners, most of whom are part of this call tonight. I want to recognize Wendy at livespecial.com, Laurie at the Upside of Downs, all of our partners at Summit County, Medina County, Portage County, and Cuyahoga County Boards of Developmental Disabilities, our partners at Milestones Autism Resources, the Autism Society of Greater Cleveland, and Friendship Circle. Again, thank you to our partners. Also, you'll notice that we will have more transition booster sessions available later this year. Those are being finalized as we speak. And if you'd like to keep up with our transition boosters in the future, please join our Facebook page at Ohio Family 2, the number 2, Family. And all of our events are also posted on our website, just so you know, at ohiof2f.org/training. So now to get to the heart of tonight's topic. We're so excited to have Derek Graham presenting tonight. Derek is an attorney from Resch, Root, Phillips, and Graham law offices. Derek's practice areas are in estate planning, special needs estate planning, developmental disabilities law, guardianship, probate, and more. You'll understand now why he's a great presenter for this topic tonight. Thank you again, all of you, for joining us, and thank you to Derek for sharing his time and knowledge. And now, with that, I'll pass the mic over to Derek. Thank you.
Thank you, Amy. I really appreciate you having me here tonight. I think these programs are just remarkably valuable for parents and individuals and just family members, because there's a lot of confusion around some of these topics. And I think it's great that you guys are shedding light on some of that confusion. So a little bit about me. I've been practicing law for 16 years. And the first 4 years, I was happily doing litigation and business work and contracts and all that boring stuff. And then 12 years ago, my wife and I had our first daughter. We now have 3 daughters, but my oldest daughter was born 12 years ago, and she was born with Down syndrome. And so that threw me into the world of being a parent of a child with Down syndrome and being a parent of a child with special needs. Well, up until that time, I had done a little estate planning, but not a whole lot of estate planning. And anytime I encountered something that involved special needs estate planning, I would immediately refer it out because I knew it was complicated and it was an area that you could get yourself into trouble with if you didn't know what you were doing. Well, I had one client that kept threatening to fire me and get a different attorney if I didn't figure out how to answer her questions on special needs planning and what was involved. And that client was my wife. And I wasn't willing to let her realize how easy I was to replace. So I finally connected with an attorney from the Department of Developmental Disabilities named David Zwire. Became very good friends with David Zwire, used to meet with him all the time. And slowly over a course of a couple of years, I started learning a lot about developmental disability law. And I realized one of the problems in a lot of the developmental disability law areas are you can ask 3 experts, what the answer is to a question, and you get 5 different answers because there's a lot of different people that give different information. And over the course of several years, it just became something that very organically became more and more of what I do. And now I spend my days doing nothing but working with families who have loved ones with developmental disabilities. And I love it. I love coming to work. I love dealing with the families. I remember when my daughter was born, just how confused and foggy it was trying to figure out why I should now care about Medicaid and what is Medicaid, because I didn't even really know at the time, other than it's some government program that pays for healthcare. And I just remember how confused I was in those early stages. And now I love meeting with families that have the same confusion and being able to work with them and kind of get that confusion out of the way. So they do have a better understanding as to how the system operates. Now, when I talk about any type of developmental disability law, and tonight we're going to talk about special needs planning and stable accounts and what's involved with that. But one thing I always tell families is I'm always remembering something that was said to me in the first week of law school. And that is that to understand the law, you have to understand it's very circular, and you have to understand a little bit of everything to understand a lot of anything. And I have learned over the last 12 years that our developmental disability system in Ohio, we have a very good developmental disability system in Ohio, but it's very circular. And you have to know some of all of it to understand any of it. And that, I think that's sometimes where some of the confusion comes in for families. But tonight we're going to talk about a specific part of it, and that's planning and estate planning. And so let me change my slide here. When we're talking about estate planning, why are we talking about estate planning? I like to do this presentation. Obviously, I miss the days when we could meet in person and have live presentations, but I don't think that's going to come back for a while. So one of the things I would always ask when I was doing a large presentation is, don't raise your hands, but how many people in the room currently have an estate plan? It's one of those things that I think if you ask any parent of a child with special needs, at some point in their lifetime, they have heard that they need to have a special needs estate plan, or they've heard they need to have an estate plan. But a lot of them don't necessarily understand why. They don't know the why they need that special plan and what's at risk for not having that plan. What I like to say to people is all of you have an estate plan. Whether you have gone to an attorney's office and signed documents or you've never given it a single thought until tonight, what I can tell you is that every single person taking this class tonight already has an estate plan. Because in Ohio, like every other state, we have a series of laws that dictate what's going to happen to your assets when you die. So when it comes to estate planning, you either have the estate plan that you've created for yourself, which would be hiring an attorney or hopefully hiring an attorney or doing something to create an estate plan, or you have the estate plan the government has created for you. And unfortunately, the estate plan that the state of Ohio has created for you, it's called our probate process, or when you die intestate without a will, that does not work well. It causes a lot of hardship if you have a loved one or a family member with special needs. So one of the takeaways for tonight is you already have an estate plan. And so it's not should you get one or not, it's do you have the right plan? And that's why it's critical to understand some of the topics we're going to talk about tonight. Like I said, a lot of you might have that lost, confused look or feeling, and we're going to try to shed some light and get rid of some of that fog tonight so you have a better understanding about what I'm talking about when I talk about planning. Now, one thing, I love questions. So please, I've got some wonderful people helping tonight. Do not hesitate to put questions in the chat. That doesn't mean they'll stop me and ask the question right then, but I'm going to stick around. We're scheduled for an hour and a half tonight, and I'm not going to talk probably less than even an hour because I want there to be lots of time for you to ask questions and me to answer those questions. So if you want to put those in the chat, that's great. I'd be happy to answer those at the end. And I think I hope at least a lot of the questions will get answered as we go through the program as well. So why are we doing this planning? Why do you need a special needs plan? Me having 3 kids, I have 3 daughters. Like I said, my oldest daughter has Down syndrome. Why do I have to do something unique for her that I don't have to do for the other 2? And I'm sure you've heard this before, but it all goes back to protecting eligibility for Medicaid and SSI. Now, I remember being in that hospital when Megan's born, and you have social workers giving you literature on Help Me Grow and other things. And there's, at the time, there was stuff in there about getting on a waiting list for Medicaid. And for me, it all just went right in the trash because I didn't know why I was supposed to care about Medicaid at that point in time. My wife and I, we had good health insurance. So why do I need Medicaid? Why would I care about this newborn baby protecting eligibility for Medicaid? Fast forward 12 years. And when I think of Medicaid today, I certainly think of healthcare. That is a component of it. It's a big component of it. But when I think of Medicaid and when I think of protecting eligibility for Medicaid, I think about independence. One of the things that's really hard for parents of young children to do, young children that have developmental disabilities, is picture what will adulthood look like. It's always a mystery. For my wife and I, it was a big mystery. What's it going to be like when Megan's an adult? And if someone had said to me when she was first born, it's not that you need to think about Medicaid, but you need to think about protecting independence, I would have thought about it very differently. But now when I think about Medicaid, again, health insurance or health coverage is certainly a component of it. But when I think about protecting eligibility for Medicaid, I'm thinking about protecting eligibility for Medicaid waivers, and I'm thinking about protecting eligibility for assistance with independence. And that's what I want for my daughter when she's older. Another program that goes along with independence is SSI. SSI stands for Supplemental Security Income. It's part of the Social Security program, and we'll talk more about it as the night goes on, but that provides supports for the individuals who are age blind or disabled. With both of these programs, with both of these benefits, you're eligible based on meeting a certain level of care and having that developmental disability. But then your eligibility is also tied to meeting financial criteria and meeting financial eligibility requirements. You can't have assets of more than $2,000 in your name. Now, with all government programs, there are exceptions like buy-in programs and other exceptions to that rule. But the general rule of thumb is you can't have assets of more than $2,000. And so that becomes problematic because when we talk about estate planning, we're talking about passing assets from one generation to the next. And you're likely to have more than $2,000 that passes to that next generation. So that's why it becomes critical. Medicaid waivers. People hear about Medicaid waivers all the time and they think, all right, what is a waiver? Why does it matter? For me, understanding the importance of waivers, it ties back to independence, but to really understand, a lot of people, I don't think, realize what they mean when they say waiver. And history matters when we're talking about Medicaid waivers. I'm a history buff. I love to read about history. And one of the things I've spent some time reading about is the history of Medicaid. So we had a federal program that started in 1955 that really didn't work well. And then in 1965, the federal government created Medicaid. Now, honestly, the reason they created Medicaid, to be very frank, it will make your skin crawl a little bit to think about. At that time, in most states, a lot of individuals with developmental disabilities were placed in institutions. It's something that as parents, it just absolutely makes your skin crawl to think about. But that's what was happening. And that was very expensive for the states to maintain those institutions, and some of them didn't maintain the institutions. What they did, they went to the federal government and said, we need help paying for this. And Medicaid was part of the federal government's response. Okay, we're going to allocate federal tax dollars to help offset that expense. And Medicaid was what was created. Now, when they passed Medicaid, it was restricted, and those federal funds could only be used to pay for one thing. And that was the long-term care placement in a 24/7 facility for people who were age blind or disabled. Fast forward many years, and that's part of what led to the downfall of institutions, because once they started giving states those federal funds, they sent in regulators to see how the funds were being used and what was happening with those dollars. And that shed light on some of the just horrendous conditions. And that's a small part of what led to the downfall of that horrible part of history. Fast forward many years. And Medicaid throughout the 70s and early 80s, it was still only to be used to pay for the care of someone who is living in a 24/7 facility. Well, they realized that's expensive. And so they wanted to allow the states to use that money to give resources to the individuals so they could stay in the community, because the individual with a developmental disability staying in the community cost the government less than having them live in a facility. And through a series of events, that's what gave birth to Medicaid waivers as we know it. What's being waived is you're being given access to these federal funds, and they're waiving the requirement that the person live in a 24/7 facility and saying, instead, let's use this money in a way that enables you to stay living out in the community where you don't need as much help. It's kind of offensive in ways, but that ultimately is where the term Medicaid waiver started and what it is. So in Ohio, we have a whole series of waivers. Specific to the developmental disability system, we have 3 waivers: the level 1 waiver, the self waiver, and the IO waiver. Now, not everyone in the developmental disability system has one of these 3 waivers, but the overwhelming majority of individuals in the developmental disability system who have a waiver will have one of these 3. So now I've told you that these waivers exist. And if you have a younger child, you might not have one of these waivers yet. My daughter is 12 and she doesn't have a waiver. And to be very honest with you, at this point, we don't need a waiver. But when she gets closer to adulthood, we will. And that's when we'll start advocating for one and pursuing that for her. Now, here's something to consider. Ohio, I'll give them credit that they're very transparent with what they do with their waivers. And so if you're looking at the Department of Medicaid, they publish a spreadsheet every month saying how many people have a waiver, how much is used on those waivers. And so I like to share this sometimes with clients to put into perspective. When you look here on this slide that's in front of you, you'll see that as of December of 2020 in Ohio, there were 15,317 individuals who had a level 1 waiver. Now, a level 1 waiver is oftentimes the waiver you start with when you get a waiver. It's my understanding you've had some sessions in the past on waivers, and we now go through what's called a needs assessment to get that waiver. But once you get a waiver, in most circumstances, that first one you're going to get is that level 1 waiver. 15,000 people have it. And there's a whole series of rules and cost caps on how the money can be used. But if you look at the total expense of those waivers and you average it out for those 15,317 people, as of December of last year, the average amount spent on those waivers is $11,365. Now, the majority of that money is centered around paying for things like day programming and homemaker personal care services and possibly transportation costs and things that promote and provide independence to persons with developmental disabilities. So that's a lot of money. That's a whole lot of money. We also in Ohio have the self waiver. Now, there are a lot of opinions on the self waiver. In my personal opinion, the self waiver is not my favorite. I would much prefer to see clients have a level 1 waiver than go to an IO waiver. There are lots of people in the system who disagree with me on that, and they have very valid points. As of December of last year, there were 2,086 people in the state of Ohio who had a self waiver. Now, the spending cap for a self waiver is a lot more than a level 1 waiver. Level 1 waiver, you're looking at 5,000, 8,000. There's all kinds of different rules on how that can be spent. But for the self waiver, I think as of this year, it went up to 45,000. It used to be 40,000, and now I believe it's 45,000 is the cost cap on the self waiver. So there's a lot more money that can be spent using that waiver. But if you look at the 2,000 individuals who have that waiver, your average cost on that being spent is $12,859. So it's not that much more if you average out the cost than the level 1 waiver. And then we get to the IO waiver. The IO waiver, individual options waiver, we jokingly call it sometimes the holy grail of waivers because that's what you want to work toward and get. Of all the waivers in Ohio, even when you factor in the waivers for people who are aging and not in the developmental disability system, the IO waiver has the best terms for a user or for a consumer. As of December of last year, we had 24,090 individuals in the state of Ohio who have an IO waiver. If you average out what is spent on those IO waivers, it's $63,660 a year. Now, think about that. Think about having an adult child with a developmental disability that has an IO waiver, and you have those resources available through the IO waiver, and you combine that with Social Security programs that we're going to talk about, And that's a lot of independence. Now, there's people that work at the county boards of developmental disabilities, and they're probably squirming in their seat right now because they do a great job. But what they have to do is manage expectations. And so I'll be the first to tell you, when you look at these stats, it is misleading. I don't want anyone to call their county board tomorrow and say, hey, I understand you guys spend an average of $63,000 on an IO waiver, and I'm not getting near that much, because that's not how it works. How we use the IO waiver and how the money is spent is based on assessments and something called the ODDP, and they assign funding ranges, and it's all based on needs. And I will tell you, as is always the case, I think if you looked at the median instead of the average, I think it would be a lot lower than that. So just keep that in mind so I don't get a whole bunch of hate mail tomorrow from the county boards of developmental disabilities. But these benefits that provide that independence, they're means tested. And so here I have an example. I like to show this quadrant of benefits. You have SSD or SSDI in Medicare. You have SSI in Medicaid. SSI and Medicaid are kind of the foundational benefits for persons with developmental disabilities. These are means tested. These are in large part designed to create independence and quality of life for persons with developmental disabilities. But when I say means tested, that means if you have too much money, you're not eligible for them. So where does that leave us? What does that mean when we talk about estate planning? Well, what that means is you've got to have the right kind of estate plan, because what I don't want is for my wife and I to finally get to go on that trip that we've been wanting to go on forever without the kids. And we get to go somewhere without the kids, and we get on a plane, and God forbid, but the plane goes down. And my wife and I pass away. And the money we've been able to save, which, let's be honest, we have 3 kids, so there's no money to save when you have 3 kids. But whatever we can save, and life insurance and all that stuff, we want it to be there for our children. We want it to be there to protect them, to take care of them if we're not here. And that's not just because they're minors. Even when they're adults, you want that money to be available. If we pass away and we're relying upon Ohio's estate plan, it's going to get divided up equally between my 3 kids. And it's going to be tied up in court for a long time, because if you die without an estate plan and your kid's a minor, your kid has a developmental disability, there's going to be guardianships created, and there's all kinds of procedural hurdles you have to jump and deal with when you have money in guardianship. A lot of individuals in the developmental disability system have guardianship, but it's guardianship of the person only. When you add in money, guardianship gets a lot more complicated. Long-winded way of saying don't do nothing. That's probably a double negative for you. Take action and have an estate plan. So planning prevents disruption of benefits, because what will happen if I don't do the right planning and the plane goes down and my wife and I are gone, or even something more realistic, we get older, I die, a few years later, my wife dies, my kids inherit everything. That's going to disrupt those benefits. It's going to cause problems with that Medicaid waiver. It's going to cause problems with SSI eligibility. There are all kinds of things that can go wrong if I don't have the right plan in place. But more important than planning for what could go wrong, I want to plan, and I want to have an estate plan in place, because I want to control this. I know what it means to be an advocate for my daughter. I know what it means to have a child with special needs. And I want to know that when I'm gone, I have still set up controls for what's going to be available for her in her lifetime. And so I don't want to leave that to chance. If life goes the way I'd like it to, I'm going to live a long time. And my wife and I will pass away at a ripe old age together. And then afterwards, Megan, my oldest daughter with Down syndrome, she'll have 2 wonderful sisters there to help take care of her. And they'll do it out of love and all that stuff. But I want to control that. And I want to have money available for Megan in the event she needs it during her lifetime. So what are the planning options? It used to be when you had a loved one with special needs, the go-to planning option was to disinherit them. I hate that option. I hate hearing about people hate hearing about people who have loved ones with disabilities disinheriting. It causes a lot of problems. So I'll just stick with myself as an example. My wife and I could say, you know what, let's just sign a will. We can download a will off the internet. We'll sign it. We'll leave all our money to Ruby and Leah. That's my younger 2 daughters, with a wink and a nod that, hey, we really expect you to take care of Megan, help out your sister when she needs it in life. The problem with that is anything that goes wrong in Ruby and Leah's life is going to have a very negative impact on Megan. So if Ruby or Leah go through a divorce, there goes part of that money. If Ruby or Leah start a business that fails, there goes that money. If Ruby or Leah are in a car accident and they're in a coma, you're not going to be able to use that money for Megan. If they pass away, that money is going to go to their spouse or their kids. And are they going to say, all right, that we have the money, but it's not really ours. We got to use it for Megan. There's a lot of things that can go wrong, and you're leaving a lot to chance when you disinherit someone because they have special needs. Does it protect their eligibility for benefits? Yes, but not really in a successful way. So a lot of people say, well, I have a last will and testament, because when we think about estate planning, we think about having a will, and that is certainly a component of an estate plan. However, the only place in America they care about your last will and testament is in probate court. And part of the estate plan is trying to make sure we keep things out of court because we want to keep the cost down. We want it to be efficient. That's one of the things we want to control. How much work and to-do items are there when my wife and I pass away? Ruby and Leah, they're going to have enough to do and think about. So will Megan when my wife and I are gone, without also having to hire an attorney and go to court and all that stuff. And so a last will and testament is not a reliable standalone estate plan. Having a will is an important part of an estate plan, but it's more of a fallback or a fail-safe than it is a primary component. Beneficiary designations. If you've gone to work, you get that new job, you sign up for your retirement account, or you sign up for that employer-sponsored life insurance, you fill out that beneficiary form, you list your 3 kids, you pass away, you've just kicked them off their benefits, because naming them in a beneficiary form means the money passes to them, it now belongs to them, and they have more than $2,000. So beneficiary designations are an important part of an estate plan, but you don't want to go that route. You don't ever want to just directly name the individual as a beneficiary in a life insurance or retirement plan without having more thought as to what's going to happen with that money. So then we get to a trust. And we're going to talk a lot tonight about a wholly discretionary trust, or a third-party discretionary trust. Now, what is a trust? When I say trust and I talk about a trust, I always tell families, just picture a basket. When you sign a trust agreement, so if I were doing my own estate plan, and I have, obviously, my wife and I, we have a trust agreement. And so we sign this 30-page document full of legal jargon. And that's our discretionary trust for Megan. When we sign that trust agreement, all we're really doing is creating an empty basket, because that's what a trust is. Then we structure our assets so that at the time we choose, assets are going to go into that basket. And so for my wife and I, if I pass away, everything I own is going to go to my spouse. Everything's going to go to my wife. If my wife passes away, everything's going to come to me. If both of us pass away, the money we want Megan to inherit is going to go right into that basket for her. It's not going to go through court. It's not going to go through any lengthy process. It's all going to directly go right into that basket we've set up for Megan. There are lots of different types of trusts out there. And if you turn on TV and listen to Susie Orman or one of those talk shows, you're going to hear them talk about a revocable living trust. Or if you Google trust agreement, you're almost always going to come up with some form of revocable living trust. It's the most common type of trust, even though it has a gazillion different names. And they're great because they give you the ability to provide for control and how you're going to use the assets. And you can say who the trustee is going to be. And that's what you would need if you didn't have a child with special needs. And so when I talk about planning for Ruby and Leah, my other 2 daughters who are 10 and 8, this is what I have. This is what I have that protects their money for them and gives it to them at the ages we want and the amounts we want. And it gives me the ability to parent them from beyond the grave. But for Megan, this doesn't work. So what does work for Megan is a discretionary trust. Now, I got ahead of myself on one thing that I want to back up and explain. When we're talking about a trust, and we're talking about the wholly discretionary trust, I'm going to talk about in a second. We're talking about a trust that's created by my wife and I for the benefit of Megan. Now, we're going to talk about a series of trusts right now, and there's something very important you need to listen to and understand. Our system, both the federal system and the state system, draws a big line between what's considered first-party money and third-party money. Now, the first party, in my example, is Megan, because she's the person with the developmental disability. So money that legally belongs to Megan is first party money. Money that belongs to my wife and I doesn't belong to Megan, even though it doesn't feel that way when she needs something. That money legally belongs to my wife and I, and Megan has no legal interest in that money. And so that's considered third party money. In Ohio and in the federal government, first party money and third party money are treated very differently when you have special needs. Money that Megan has a legal interest in, if it doesn't disqualify her from her benefits, and there are other types of trusts we'll talk about that are first party trusts that might not disqualify her from her benefits, it's still always going to be subject to what we call Medicaid payback. Whereas third party money, money that belongs to my wife and I, does not ever need to be subject to Medicaid payback. And I have a feeling I just confused some of you. So let me slow down and try to explain it again. The money that belongs to my wife and I has never legally belonged to Megan. She has no interest in that money. That's third party money. Until I hand it to her, until I die if I die without an estate plan, it immediately becomes first party money because she owns it. But if while I still own that money, create an estate plan for Megan, that is third party money I'm dealing with. And so I have the ability to create a trust, create that basket for Megan. And it has to be a specific type of basket. So it's not that revocable living trust I talked about a few minutes ago. I can create what's called a third party discretionary trust. Then I can put as much money as I want in that basket. So that basket for Megan, it can have $10 in it. It can have $10 million in it. It can have $10 million in it, and it will not interfere with Megan's Medicaid waiver. It won't interfere with her eligibility for SSI or any other government benefit. And that's what I want, because I want $10 million. I don't have $10 million, but whatever money I do have, I want to be able to leave Megan her share of that money. I want her to have that money so that it's there to improve the quality of her life. If she wants to go on vacation with her sisters, boom, she has that trust. The trustee can distribute money. She can go on vacation with her sisters. She wants to buy a new bedroom suit. Great. We've got a trustee that can spend that money and buy a bedroom suit for her. She wants to buy some Christmas gifts for her nieces, nephews, whatever the case may be. Great. It's there. I want that money to, in a lot of ways, replace what my wife and I do now. Because if you think about it as parents, a lot of times it just feels like you're a moving and talking wallet for your kids because they need money or they want to do an activity and they come to you and their hands out and they want the money. And someday I'm going to be gone, but I still like the idea of that moving or talking wallet being there. So if Megan needs something, she can go and get the money and have it to improve the quality of her life without minimizing my ability to utilize Medicaid waivers, and SSI to provide that independence. That's what I'm working toward. And that's what we work toward for clients. This only works, though, because the money has never belonged to Megan. If I die without creating this type of trust, the minute I die, legally, that money, Megan has an interest in that money, and it can never go into a third-party discretionary trust. Any person alive can put money in Megan's third-party discretionary trust, except Megan. And if any of you want to put money in Megan's trust, email me. I'm happy to give you the information. You can send us all the money you want, but obviously that's a joke. But that is important, though, because if grandparents want to leave money to Megan, or if there's an aunt or uncle that want to leave money to Megan, I can tell them, hey, do me a favor. I know you mentioned that you've got some money allocated for Megan in your will. Don't leave it to Megan in her name. Instead, if I give you this language or this letter from my attorney, can you leave it to this trust instead so it doesn't mess up her benefits? Grandparents love that stuff because it makes it feel like they're part of the team that's protecting and preserving those benefits. Or that aunt or uncle that doesn't have kids of their own that wants to leave money to Megan, that's wonderful. But please direct it to this third-party discretionary trust because that's going to protect eligibility for Medicaid and SSI. Now, as the person creating the trust, my role is I get to pick who the trustee is going to be. So again, in my case, we've got Aunt Julie lined up, and Aunt Julie's going to play the role of being a trustee someday, or maybe Uncle Brian, or we've got different options. And so we're always batting around who's the best person to play these different roles. And in my case, what I've done is I've said, okay, let's just say it's Aunt Julie. Aunt Julie's going to be the trustee. But again, if life goes the way I want it to, I'd want Ruby or Leah, my younger two kids, to be the ones managing that money for their sister. So we can even put in there that, hey, Aunt Julie's going to be the trustee. But once Ruby and Leah reach 30, which is a long time from now, if Aunt Julie's serving as trustee, then Ruby and Leah have the ability to step in and take over and take care of their sister. Now, that's obviously predicated upon me not being here, because again, that basket's going to sit there effectively empty until my wife and I pass away. And I say effectively empty because when you sign, at least with our office, when you sign the trust agreement, we have clients pledge $10 to that trust, and we'll have them bring in a $10 bill and we'll photocopy it. And then I make a joke about how now the last $10 you ever own belongs to Megan, not you. And it's her money, not yours. So put it somewhere safe. At that point, the trust is what we call funded, because it has a $10 of cash in that trust, but there are no accounts anywhere. We don't open accounts. We don't do anything that changes how you prepare or file your tax returns. We are not changing how your accounts are titled or anything like that right now. But now you've got this trust, it has $10 in it. Then what we do is what we do for clients is we will send that trust to the County Department of Jobs and Family Services. If the person has a waiver. If you don't have a waiver, you can't do this yet. But if they have a waiver, we go in and we send it to Jobs and Family Services and say, here's this third-party discretionary trust. It has $10 in it. Would you please review it and tell us if it's an exempt asset? And they'll look at it, or they'll contact their county prosecutor, or he'll look at it, she'll look at it. And then they'll send us a letter back saying, yep, you did it right. This is an exempt resource. And then the client has the peace of mind of knowing, and I have the peace of mind of knowing that I didn't commit malpractice. We did it right. We got a trust and it works. And then they know that when they pass away, whatever they want their child to have will funnel into that trust, and it doesn't disqualify them from any benefits. Now, in my case, my wife and I created the third-party discretionary trust. If a grandparent passes away, and let's say they're in their estate plan, they left $5,000 to Megan's discretionary trust. It's probably wishful thinking, but if that did happen, then my wife and I, as the trustees, we would just manage that money for Megan. It would be in the trust, but it would be under our control, and we would decide when and how it's spent. Now, these trusts, they sound great, and they are great, but there are some downsides to these trusts, and there are some other things you need to think about when preparing this type of trust. One of the reasons this type of trust works is because you, the person creating the trust, are not allowed to put any guidance on how the money in the trust is used. When we say discretionary trust, let's say Megan, well, let's not say, I'll just tell you for a fact, Megan loves ice cream. I mean, that kid could eat her weight in ice cream every single day and be happier for it. So what if my wife and I were to say, all right, when we're gone, we want you to put a clause in the trust that says every year on her birthday, make sure you buy her a giant ice cream cake. You can't do that. In these type of trusts, you can create the basket and you can say who's in charge of that basket when you're gone, who the trustee is going to be, but you're not allowed to give them any guidance or what we call ascertainable standards for how that money is going to be used when you're gone. And that's frustrating. Because like I said before, we have a different type of trust for Ruby and Leah, and we can spell out, hey, use it to pay for everything from soccer cleats to college someday, to whatever else comes along. And otherwise, they can't have the money till they're these ages. And for Ruby and Leah, we certainly feel that desire to help control things if we're not here. But for Megan, that's even more the case. We have a lot of opinions on what we want for Megan and what we want her life to be like, just because we worry, we want it to be the best it can possibly be. And that's natural for any parent. And so it's hard sometimes when I say to the parents, all right, we've got this trust. You can put all the money you want into it, but you have no say in how that money is spent. And that's mostly true because in the trust document, we can't put anything binding on how that money is going to be used. Or if we do, that's going to disqualify the trust and it's not going to work to protect Medicaid and SSI eligibility. But that doesn't mean there's nothing you can do in that situation. What we do there is once you create that third-party discretionary trust, we're going to have the clients work with us to create what we call our roadmap. And so I have a roadmap for Megan. And that roadmap for Megan is, it includes all kinds of details. It tells people what they need to know about Megan if my wife and I are gone. Megan's got a pretty complicated health history. We've had, multiple and lengthy open heart surgeries, and we've got more to come. And she's got, several other health issues that we've battled through over the years. There's a lot of information that, to be honest, even if something happened to my wife, I would be in trouble. If something happened to both of us, Aunt Julie is marvelous, but she's going to have a lot of researching to try to figure out what my wife and I know. And so I say to parents all the time, if you knew you were going to die tomorrow, the rest of today, when you weren't hugging your kids or crying or spending time with them, you would be feverishly writing notes, making videos, trying to leave messages about information people need to know about your kids. And that's amplified even more when the child has special needs. And so the roadmap is a function of our estate plan where we try to make parents write that information down. And a lot of it's just narrative that they write, but we also, walk them through some templates. And then once they write that down, we also encourage them, that's the place to give Aunt Julie suggestions. If it's important to you that Megan, or important to me that Megan has that, ice cream cake every year on her birthday, write in there, hey, Aunt Julie, I'm not allowed to tell you how to spend that money in that third-party discretionary trust. But if I were, here's 5 pages of instructions on what I tell you I'd like to see you do with that money from the grave. And again, none of that's binding, but put yourself in the shoes of that trustee. If I woke up tomorrow and God forbid, but one of my siblings died and I were now the guardian and guardian of one of my nieces or nephews, and I'm the trustee of money for that niece or nephew, I'd be happy to play that role, although I'd be devastated for the loss, but I'd be happy to play that role. But I would want as much guidance as I could get from my sibling for what they want for their child and what were their preferences for how they want that money spent. And so that's a lot of that roadmap process, is giving suggestions in a non-binding way on what you'd like to see done with that money. If we make it anywhere even close to binding, it jeopardizes the trust. It can't be anything more than a really fancy suggestion. But we use that roadmap so that, one, we've written down information about that person, so that if something happens to us, that information is written down, and we've put our larger philosophies. I do want Megan to travel with her sisters. Aunt Julie, Ruby, Leah, whoever the trustee is, when you guys go on trips, take Megan and absolutely let her pay for her share out of this. And if she wants to pursue something that's important to her, by all means, support it. And we can put our own philosophies on spending. And we all have that. We all have that guidance on how we'd like to see the money spent on our loved one if we're not here. That's what we use the roadmap for. And that's a critical part of the plan. Now, we certainly encourage roadmaps for our other children as well. So in our case, we have a roadmap for Ruby and Leah as well. They're not left out, but theirs is a little bit different. With the roadmaps, I like to give those to clients in a PDF or a fillable form or something like that, because I always preach to them, you're going to fill this out electronically, save it, and then you need to pick a day every year, open it up, update it, and then save it again. So that if I die, Aunt Julie has, Megan's roadmap from 2020, 2021, 2022, because it's going to change. I can't sit down right now when Megan's 12 and make a roadmap that's going to be particularly applicable when she's 30. I can't do it. So I need to just update. I can put some of my larger philosophies for what I'd like to see when she's an adult, living independent and all that stuff, but I can't write down all the details. It's going to change every year. So you got to get it out, update it, and have that be an active and living part of your plan. It's very important. Now, that trust only works with third-party money. Well, what happens if we have first-party money? What happens if we don't do the estate plan? There are other types of trusts that can be created to protect eligibility for benefits. Specifically, that's where we have a special needs trust. Now, the term special needs trust is very, very frequently misused. It's misused by a lot of attorneys. It's misused by a lot of people in the field. Here's the example I give to try to explain this. But a special needs trust is a specific type of trust that holds first-party money. Now, here's my example. If I were to go to you and say, I hear you play football. What position do you play? And your response to me is, well, I play offense. Well, that doesn't really tell me a lot. It tells me you play offense, which, okay, that narrows it down to half the positions, but it doesn't tell me if you're are you a receiver? Are you a running back? Are you a quarterback? Or are you a 300-pound lineman? Those are all very different skill sets. A lot of times when we talk about trust and planning, we use the term special needs trust the way I just used offense. We use it, and attorneys are most guilty of this. They'll use it as this broad term to apply to any type of trust that benefits a person with special needs. In the statutes, in the revised code, and in the federal statutes, that is not what a special needs trust is. A special needs trust is a specific position. It's a type of trust that was created strictly to hold first-party money that belongs to the individual with a developmental disability, not money that belonged to mom or dad. Now, if you've hired an attorney and done your estate plan and you're thinking, wait a minute, I have a first party, or I have a special needs trust. That doesn't mean the attorney necessarily did the wrong thing. It might just mean they used the wrong title. What matters is what the trust says. But a first party special needs trust can be created by the individual, parent, grandparent, legal guardian, or court. And when we create that type of trust, it's a different type of basket, but that's a basket designed to hold money that belongs to Megan. So to give you an example, let's say Megan were in a car accident, and maybe she's injured by a reckless drunk driver. And the drunk driver has a lot of money. So we sue the reckless driver because shame on you, you're a drunk driver and you injured Megan. And in that lawsuit, we win $100,000. That $100,000 from the lawsuit, that belongs to Megan. I mean, the minute that's paid, that money belongs to Megan, and it will disqualify her from Medicaid and SSI. We cannot put that in a third-party trust. We can't put that in a third-party discretionary trust. We can put it in a first-party special needs trust. Now, a first-party special needs trust is not as good as a third-party discretionary trust for a variety of reasons. There are more limitations and restrictions on how the money can be used, first of all. So it's not as broad a category of things that the money can be used on. Secondly, when Megan dies, the state of Ohio is going to look to that special needs trust to say, all right, whatever money is left in that trust first has to be used to pay us back for any money we have spent on behalf of Megan. That's not what we want. If something happens to Megan and my wife and I's money goes into that third-party discretionary trust, or if something happens to my wife and I and our money goes in that third-party discretionary trust, and then Megan dies, I want any money left in that trust to go back to my other kids. I want it to go to Ruby and Leah. And I can do that in a third-party discretionary trust. I can't do that in a first-party special needs trust because it has to say, for it to work, it first has to say, any money left is going to pay back the state of Ohio for whatever they have spent on Megan's behalf. It's unavoidable to need a first-party special needs trust in the context of a lawsuit or something like that. There aren't other options unless it's a smaller amount. Then we look at a stable account, which we'll talk about in a second. But for estate planning, we should never be bound to a first-party special needs trust. The only reason we ever get here is if mom and dad don't do the estate planning, they die, Megan inherits all the money, it kicks her off her benefits, we have disrupted benefits. Now we have to go to court most times to establish that special needs trust. We get the benefits turned back on, but it takes a couple of months. And now we're stuck with a trust that has more restrictions on how the money can be used. And we don't have any control over where the money goes someday when Megan dies. So it's not as good of an option, but it is certainly a valuable option in the context of a lawsuit or something like that. You'll also hear about what we call a pooled trust. A pooled trust can be created by an individual, a parent, guardian. Now, we have a pooled trusts are going to be run by nonprofits. We have a couple in Ohio that manage pooled trusts for individuals. We have Community Fund Management Foundation. We have Dayton Foundation. Personally, I don't have experience working with the Dayton Foundation. I've had several clients use Community Fund, and I have great things to say about them. They do good work for what they do. A pooled trust becomes an option when you don't have someone readily identifiable as a trustee, or possibly you don't want the person that's going to serve as trustee to have to deal with all the administrative work that can sometimes come with being a trustee. Then you can go to one of these nonprofits like Community Fund, and you can use a pooled trust option. And you can use, when I say a pooled trust, it can be a first party special needs pooled trust where it's money that belongs to Megan, or it can be a third party pooled trust where you're using community fund, but the money never legally belonged to Megan. So you still have control over where it goes someday when Megan passes away. These nonprofits offer both types. Obviously, with anything, it's not free. So you are paying them for their service as trustee. And it's a function of looking at the cost and the viability and what's right for your situation. Pooled trusts are not good for every situation, and they're wonderful for some situations. It's very much a case by case in terms of when it's applicable and when it's not. And again, that's in my opinion. And different people have different opinions on pooled trusts, but I've had good experiences with them for clients that have used them. And again, my experience has only been with community fund. But you have to understand how it works. And you do have to understand it, like with everything else, there are pros and cons to using it. The pros are a lot of the work, the administrative work of having a trust is taken care of for you. The cons are there is a cost for it. And there also might be a delay. It might not operate as quickly as you want it to in certain circumstances. That leads us into stable accounts. So we've talked about trusts. We talked about that third-party discretionary trust. Then we talked about special needs trust. Then we talked about pooled trust. Now we're going to talk about stable accounts. Stable accounts are another tool that we use as part of a broader plan. Stable accounts are great, but you have to understand when and where they fit into the overall plan. Stable accounts are not accounts you open on your own at a bank. They're accounts you open on your own, but you do it online through the Ohio Treasurer's Office. I will say the Ohio Treasurer has done a wonderful job rolling out stable accounts. That when the ABLE Act passed several years ago, the state of Ohio was very aggressive in getting the word out on stable accounts. And I have nothing but good things to say about the crew over there that run the stable accounts. This is an account you open online through the state of Ohio Treasurer's Office. When you open it online, it's great for a lot of reasons. You know, we all have that thought in our head that when our kid reaches the right age, we're going to help them open their first bank account. We're going to help them learn money management. With Megan, certainly money management is something that it's a work in progress. And she's not quite ready to open her own bank account yet, but she will be soon. And when she is, we're going to open a stable account. And so a stable account is an account that I can open with her. We can deposit money into this account. And then we know that there are all kinds of bells and whistles that make it very user-friendly for individuals with special needs. Now, money that goes into a stable account does not count towards the $2,000 asset limit for Medicaid or SSI. So I can put money in a stable account and not worry about whether it's going to kick her off one of her benefits, which is great. That's good. It gives us a way to help save money. I represent a statewide agency that I'm sure a lot of you have heard of, and most of you have probably never heard of. And it goes by the acronym of APSE. And APSE is guardian of the person for adults with developmental disabilities who don't have someone else to be the guardian. And one of the things that used to drive me up a wall before we had stable accounts is you had a lot of individuals with developmental disabilities who had low income or income that was controlled by caps with SSI and other sources. They would save what little money they could, but every couple of months, their balance in their checking account would get up above $2,000, and they had to get it back down below $2,000 before the end of the month. And so you would literally have providers out in the field loading up a van on the last day of the month and driving to Walmart or Best Buy just so that people who have developmental disabilities could go in and spend money because they had to spend it to get back down below the right threshold. And it's such a waste because you want those individuals to be able to save money in a meaningful way, just like you or I can. And that's where the stable account fits in. And it's great because individuals can save money. It's first party money. It's money that belongs to them in this account, but they can save that first party money and not worry about losing eligibility for SSI or Medicaid. There are contribution limits. So you can only put up to $15,000 a year in a stable account. And if you try to send them $15,010, they're going to mail you a check for $10 back and say, we can't take that. Because of a couple of reasons, it's not ideal for estate planning. So it's part of a plan, but it's not something where if you're a mom or dad and you're thinking, should I just start putting $15,000 a year in the stable account? My answer would be a very definitive no, don't do that. When you're putting that money in the stable account, you have to understand it's there and it can only be used for the beneficiary, but it is a first party account, meaning whatever money is left in that account when the individual dies will go to their estate, and it will first be used to pay for funeral and burial, which is good. And then after that, it's going to have to be used to pay back the state of Ohio for whatever amounts they've spent. And if you think back to that waiver slide early in the presentation, it doesn't take very many years for somebody with a waiver to have a pretty big balance they owe the state. And that's not even counting what the state may have spent on healthcare through Medicaid. So there can be a big balance owed through Medicaid. So we like stable accounts because it gives us a way to empower the individual. I like stable accounts because when Megan's older and she wants to take a credit card with her friends, and maybe they're going to the state fair for the day or Cedar Point or something like that, I can have that stable account, and maybe I put a couple $1,000s in it to open it up. And I can give that debit card to Megan, and then I can jump online as her parent and I can program that card. So I can say, okay, I want this card to only access, $80. So I don't have to worry if Megan goes to Cedar Point with her friends. That card that she's carrying around has access to $80. And that's not to say she can't be taken advantage of for that $80. She can, but I don't have to worry about someone charging her, $1,000 for a snow cone that should have been $1, because I don't have to worry about that level of exploitation. So there's some safeguards there. I also like stable accounts because they are user-friendly. In the office, I find they're very adept and used to dealing with families who have loved ones with special needs. So when you call them for the 5th time in a month and tell them your child lost their 5th debit card in a month, there's no judgment on the other end or those questions that sometimes you might get in other settings. They're used to working with individuals with developmental disabilities, and I think they do a good job of it. Something else you need to know about stable accounts is there is a tax advantage to putting money in a stable account. When you contribute money to a stable account, it's the same as contributing money to a 529. When you contribute money to a 529 college savings account, you get a tax deduction for that contribution. And likewise, you can also get a tax deduction for contributions to a stable account for the same amount, up to $4,000. So if you're going to itemize on your taxes, you're not wrong to say, okay, I think I'm going to contribute $4,000 to my stable account every January, not spend another dime on my child with special needs until that $4,000 is gone, because I want to keep a relatively low balance in the stable account. And now what I've done is I've created a tax deduction for myself. That works. It's, again, very situational specific, but that can work. There is ways that you can do that very appropriately. If you want to create one, it's done online. I think they're even going to put a link in the chat for you as well. So that account is created online through the treasurer's office. It's a very user-friendly website. And I would encourage you, if you just have those small amounts, maybe your loved one is working and earning wages every month, and so they're creeping up towards that $2,000 limit and maybe their rep payee account or something like that. And you don't want to just blow the money, but you certainly don't need to go pay an attorney for a first party special needs trust to save that extra $600. Open a stable account. They're great for that. And it gives you a way to build up those savings and plan long-term. Now, once it's in the stable account, what can it be used for? Well, we know in the rules, they list the reasons it can be used. But I will give a lot of credit to the state of Ohio, because their interpretation is it can be used for just about anything that makes the person's quality of life better. And now there are some exceptions. It can't be used for alcohol and certain things like that. But people always ask, well, can I use it for vacation? And I've heard people from the treasurer's office say many times, if you tell us that vacation improves the quality of your life, then yes, it can be used for vacation. That's the state's interpretation that I've heard them represent many times. I always worry that somebody's going to abuse it and there'll be some kind of federal or court interpretation that's more strict. But as of right now, if you can justify it improves the quality of your life, you're in good standing to use that money. And that's great. That's the way it should be. So you can save that money. You can set a goal for yourself, build up, save money that's first party money without worrying about losing eligibility for any of your government benefits. So let's talk in summary, because I want to leave a lot of time for questions and answers. What do you actually need? If you're the parent and you have a child or loved one with special needs, you need to have a third-party discretionary trust. When I meet with families that don't have children with special needs, and let's just say your average family that's got 3 kids, I sit down and I explain the different options that you could do this or you could do that. And these are your options. When I would meet with families that look like mine, 3 kids, but one of them has Down syndrome, you don't really have options. I can tell you exactly what you need. You need a third-party discretionary trust. We need to build your plan this way. You need to have a roadmap that helps give guidance for that child and the money that's going to be in that trust. That's what you need. If you have other children, depending on their ages or their spending habits or your desire to control the money they receive from you, you might also need a revocable living trust. But again, that's very fact specific to each client. You need to have a last will and testament. Part of your estate plan should include having that last will and testament. But that's kind of a safety measure. I don't ever want us to rely upon the last will and testament. And I always joke with clients when they sign their will, I hope of all the documents you're signing that one's the most useless. Because if you're using that will, it means we're in court and we're going to try to make sure we don't go to court. Your estate plan should always factor in decision-making. And I know you've had trainings before on guardianship and alternatives, and we spend a lot of time talking about that. But when it comes to decision-making, every single person who is over the age of 18 and has capacity to do so should sign power of attorneys, because that creates an ability in someone else to make decisions for you when you can't. So part of your estate plan should be that general durable power of attorney. It should be that healthcare power of attorney, other advanced directives like a living will. If I have a stroke tomorrow, well, think of it this way. Maybe you're married and you think, well, yeah, power of attorney, that sounds important, but if something happens to me, my wife's name is on all the accounts. Well, are they? Because I think what you'll find if you dig deep is that's not always the case. If I have a stroke tomorrow and my wife's going to have a lot on her plate, she's going to have our 3 kids, which is already a handful, a wonderful handful, but it's a handful. And now she's going to have a husband that needs a lot of care. And my wife has a full-time job of her own. So maybe she's going to need to dip into our savings. Not maybe, she would. She'd need to dip into our savings to help absorb the costs associated with my disability. Maybe she needs to dip into my retirement savings. Well, you know what? She can't, because a retirement account, a qualified account, a 401k, an IRA, those can't be joint accounts. Those are going to be in the name of one person, and it's going to be in my name. And unless she has a valid power of attorney to show he's given me authority to access his retirement account, that account pretty much gets shut down with my disability until someone goes to court and establishes legal guardianship of me. And now you've added even more headache to her already full plate. That's not a good scenario. And so as people age, power of attorneys become very, very important. In families that don't have loved ones with special needs, and if you were to tell me, my parents, I have 2 brothers, and to all jokes aside, none of us have any special needs or considerations. If my parents, you were to tell me they can have one of 2 things, they can have a will and a trust, or they can have power of attorneys, I would pick mom, dad, get the power of attorneys, because that's going to save more money and more headache having those in place than having the will and trust would. Special needs trust, pooled trust, those are always a maybe. It's very rare. We never create first-party special needs trusts proactively for clients. If someone's coming in and we're creating a first-party special needs trust, it's because a specific situation has arisen where they need it. Those things are kind of a pain to deal with. And so we don't want to deal with them. We don't want you to have to deal with the pain of having them unless you actually need it. And then part of estate planning is always going to be funding, roadmaps, instructions, details. And I don't mean roadmap in the context I used it earlier. I'm talking about making sure that you know how your assets are going to pass when you die, so that you know they're not going to go through court. And I also mean writing down details. 25 years ago, if somebody died, you could read their mail for a month and you knew everything about them. Now, I know Amy Clausen a little bit, so I'm going to make a guess. And I don't know if this guess is true or not. But if she died, I bet I could read her mail for a month, and I probably wouldn't know a lot about her if I read her just physical mail, because I have a guess that she does online banking, and she might have, her homeowner's insurance. She doesn't get a statement in it every month anymore, because for most of us, we don't get that kind of mail. It's all done online. I like to use myself as an example in this context, because when my wife and I had Megan, I went out and got a life insurance policy, and it felt responsible. I shopped around. I found what I thought to be the cheapest and best policy out there. So I get this life insurance policy. I get a bill for that policy because I pay the premium one time a year. I get a bill every year. I get an email on May 1st saying my bill is due. I pay it anywhere from May 1st to May 10th. And then around May 20th, I get an email saying, thanks for your payment. Your policy is still in good force and effect. After that, I don't hear a peep from them till the following May. I don't get anything in the mail. And I've joked many times to my wife, I might just be paying some scammer in a different country and not have any insurance at all, because it feels weird. If my wife and I both passed away and I haven't written down information about that policy and I haven't mapped that out for Aunt Julie or whoever's controlling our money, how are they going to know about that policy? Unless they just happen to check my email between May 1st and May 20th, how are they going to know in the middle of December that I have this life insurance policy that they need to go submit a claim on? And so what we see in Ohio is unclaimed funds is going up drastically because information is slipping through the cracks. The digital age is great for a lot of things, but it's been hard on estate planners trying to pass information from one generation to the next. And so you got to map out the details. Some red flags to think about when you're doing this type of estate planning. Again, somebody being disinherited to me is always a red flag. That plan very, very rarely works out the way parents often want it to. If you ever hear somebody trying to sell you an annuity associated with your estate plan, we do see this from time to time. To me, that's a red flag. When you create an estate plan for a child or loved one with special needs, there's nothing about that plan that should require you to buy certain financial products or open certain financial accounts at this time. Retirement accounts need some special consideration. And I say that because there are some good things about retirement accounts. There were some changes to the law a year and a half ago called the Secure Act, where it changed the time limits in which we have to withdraw or take out minimum distributions of retirement accounts. And there are some planning things you can do with retirement accounts that are a lot better for individuals with developmental disabilities. Megan, if you were to say, Derek, only one of your kids can inherit your 401k. Well, to be very frank, if Megan inherits that, she's going to pay a whole lot less tax over her lifetime than Leah or Ruby would. And so there's some special things you can look at with respect to retirement accounts. SSI, SSDI, I'm sure you've had presentations on this before, but make sure you're on the right benefits. I mean, SSI is a program that you're going to be eligible for based on the fact that you have a qualifying disability and you meet the financial eligibility criteria. But a lot of individuals with special needs, you can say graduate or move on to SSD, which could be adult disabled child benefits or child survivor benefits, or all kinds of other classifications where they can draw a different Social Security benefit based on what their parent has paid in and done, not based on what they're eligible for. And so make sure you're on the right benefit. Last but not least, I'm going to open it up to questions. Before I open it up to questions, I always try to caution, especially in large groups, please don't ask a question that's remarkably detailed with personal information. We've had that happen before, and it gets a little bit awkward for you and for me. And please don't be offended if some of the questions I say, you know what, let's talk about that offline. And I think some of the folks helping will weed some of those questions out to begin with. If you want to talk to me privately or you want to have a consultation, we never charge anyone for a first meeting. We got a QR code here. You're always welcome to contact our office. We represent clients all over the state of Ohio. Zoom has actually made that a lot easier for us. I'm happy to meet with you and work with you. But more than that, I want to make sure I give you some knowledge tonight that's going to help you and gives you the right questions to ask and think about for the attorney you do meet with when you go to do this type of planning. So I'll leave that up for now. Are there any other, well, the next slide has my contact information. I'll share that in a second if you don't want to do the QR code. But I think this would be a good time to start taking some questions. So if you have questions, put them in the chat, please.
Thank you so much, Derek. I'll ask Laurie and Wendy if they can prepare us with some great questions from the chat now. Thank you.
I always wonder if no questions means I have you so thoroughly confused you don't even know what to ask, or I actually did a good job and you understand what I was talking about. So
we do have
some. We have some.
Yep, we have some good ones.
Wendy, I could just do the first one.
Yeah,
we could take
yeah, go ahead.
Okay. Thank you for this informative presentation. Can a parent be the designated HPC homemaker personal care, and or provide transportation for getting to and from a job. Currently, we have no waiver. Daughter is almost 22 and would probably qualify for a waiver if assessed. Do you recommend applying for a waiver for these services? She has SSI and Medicaid. Thank you.
So let me work backwards. Yes, I do recommend applying for a waiver. And when you apply for a waiver, you'll do that through your SSA. We have a very acronym heavy system that's Service and Support Administrator, which has a different name in a lot of different counties, but that's technically what it is. They will arrange for a needs assessment. And so they'll come out and say, okay, they're looking for current needs, emerging needs, immediate needs. Whether or not you go back or to a waiting list for a waiver depends on how that assessment plays out. Now, there's a whole different program I do on advocacy and how to behave in those assessments. But one thing I will say, when you do those type of assessments and you're applying for those programs, be very mindful of what I call the prideful parent trap. My wife and I have a running joke that she will never be allowed to go to any assessment of any kind with our daughter. And that is because if you talk to my wife, you would think Megan is the smartest girl on planet Earth and doesn't need any help from anyone for anything. And I love that about my wife, but she cannot talk about my daughter in terms of what her weaknesses are. She sees the best in her, and that's great. But it's bad when you go to an assessment, right? And it's one of the things that I don't like about our system is a lot of these assessments, you're doing them in the room with the individual. And so when doing those assessments, remember, you need to describe your loved one on their worst day, not their best day. You don't ever want to lie. You don't ever want to overstate the truth, but you want to remember to talk about them on their worst day, not their best day. Now, can you be an HBC provider? Sure. You can go ahead about the process of when you say you don't have a waiver, you probably already are the provider. When you say HBC provider, to me, that means you have a waiver or funding source to help pay for those HBC hours. And then you'd have to go through the process of getting licensed and approved. There's some training and other steps you have to take to become an independent paid provider. One thing I will tell you to be aware of, if you're the legal guardian for your loved one, you do have to get court approval to become an HBC provider. And that's, in some counties, it's a remarkably easy process. And in other counties, a little bit more difficult. So I think I answered most of the question, but it was a long one and had different parts. If I missed a part, please tell me.
Okay, the next question that you have is they want to know the cost for setting up a third-party trust. What costs are associated with that? Yes,
great question. It really depends on a variety of factors in what we're doing. It can range anywhere from, $2,500 to $3,000 to higher, depending on a variety of different things. And it costs different things in different parts of the state. And, are we getting it approved by Jobs and Family Services or not? I mean, what I like to do and what we do here at my firm, and every attorney does it differently, is we meet with the client. There's no cost for that. We figure out what exactly they need, and then we can give them a very precise flat fee so that whether we meet 5 times during the process or 10 times during the process, you know exactly what it's going to cost and what you pay. And then we're available to answer questions as much as you need as things progress. So the range really varies. I think if you averaged it out with all attorneys across the state, you'd probably be in that $2,500 to $3,000 range.
Okay, next question. Can you please share some roadmap templates?
So I can look at that. I mean, that's part of the service we provide to clients. And so, yes, here's what I would encourage you. If you're trying to create a roadmap and you're not engaging an attorney to do it, what I would encourage you to do is just open up a Microsoft Word, open up a document and just write down the information that people need to know. We have questionnaire type templates that we make clients start with, but I'll be honest with you, the questions don't matter. What matters the most, and I say this to every client, is the narrative you write at the end. There's no way anyone's going to create a template that's going to describe every unique circumstance regarding your child. And that's information you have. And I would encourage you to just put pen to paper. When it comes to that part of the roadmap, honestly, the biggest thing we do is we make you do it. I mean, we put pressure on you to do it, but there's nothing magical about our templates.
All right, the next question is, when did stable accounts come to be?
Stable accounts, I could be off a year or two. I believe the ABLE Act passed. It was either 2014 or 2015. They've now been around in the state of Ohio. Once they passed it, it was the ABLE Act that passed at the federal level. And so the state of Ohio jumped on it, and then they put their own twist on the name, calling them stable accounts. And they are truly the nationwide leader in ABLE Act accounts, or as we know them, stable accounts. So much so that the several other states didn't even try to create one. They're just contracting with Ohio. And so if people in that state want a stable account, they go through Ohio to get one. So yeah, it was either, I think it passed in 2014 or 15, but I could be off by a year.
Okay, next question. We have a special needs will and trust for my 18-year-old son with autism, and I recently opened a stable account. Do I need to close it because of it being first-party money?
Not at all. Not at all. Stable accounts are a good thing. I have every intention of opening a stable account for my daughter, and I've opened stable accounts for a whole bunch of clients. I've been appointed legal guardian in a few cases, and I've opened stable accounts for the people that I'm guardian for. They're a wonderful tool to have. But again, you have to understand what they're for. It's a mechanism to put overflow money that belongs to the individual. So it's a great place to catch overflow money. And then if a lot of times what we'll do, if mom and dad pass away and they have a third-party discretionary trust, we will link accounts within that third-party discretionary trust to the stable account. So if, Megan's living her best life and she's independent and going to work part of the day and day programming part of the day, or whatever she decides she's doing that makes her life the best it can be, and she needs some spending money, we can have that third-party discretionary trust automatically deposit, $50 in that stable account every Monday. So Megan's got that card she's carrying around that gives her access to that spending money. There are all kinds of great things you can do with stable accounts. So I would never, ever suggest not having one. I just suggest knowing what your purpose for it is and not just blindly dumping $15,000 a year into it.
Thank you. Okay, the next question is, what is the best option for an adult 18 child that will never live independently or be able to use a bank card? Also, what happens to a child if we don't have any family or friends to take care of her when we're gone? So I think it's a two-part question.
Yeah. I'm sorry, can you read the first part again, Wendy?
Yeah, the first part is, what is the best option for, I think they're asking, what is the best option for an 18-year-old child who will never live independently or be able to use a bank card?
So when you say what is the best option for a child that will never live independently, we all need assistance. And so independence means different things to different people. In Ohio, when we talk about housing options, obviously there's private residences, you always hear the term group home, even though it's not usually used absolutely correctly. There's lots of ways you can use waivers and other resources to create a good living situation for yourself. We do have what's called ICF, intermediate care facilities in Ohio. If you have a certain level of medical needs or other needs, that might be appropriate. There are all kinds of options and opinions on housing options. And I would encourage you, if you want to know what are the options, ask your SSA to sit down with you and explain those. And if they can't, call us or someone, we can do what we call a benefits consultation, where you just talk, what are the options? And for housing, it's a little tricky though, because some of the housing options are very county specific, and it can be very dependent upon local levy dollars and what's passed and what's available. And I hate it that that's true, but in some of the poorer counties, you're not going to have as many options as you are some of the other counties. And it really just depends on a variety of factors, but you should be able to get answers to all those questions. Now, what happens if, and I don't mean to not, let me back up. I don't mean to dodge the question, because I am kind of dodging it, because that's a whole different program in and of itself in terms of what are the housing options. But moving past that to the second one, what happens if there's no one available? The County Board of Developmental Disabilities has a statutory obligation to help look after and control the health and safety of that person with a developmental disability. Ohio's developmental disability system is in large part very good. And I find that a lot of the people that work with the county boards and otherwise are very well intended. And that's not to say we don't sometimes have disagreements, we do, but by and large, the county board SSAs do a very good job. They would have to, if you were to disappear and your loved one needs that assistance, they would have to, put supports in place to help meet the needs of that individual. And that can look like a lot of different things. That's very dependent on what are the circumstances going on in your loved one's life. Now, one thing I'll share, and this is true, in Ohio, I say it many times, we have a very good system. You always can find the horror stories. If you want to find a parent who's had a bad experience, or you want to find somebody that will talk about abuse or something like that, you don't have to look far. You can always find those bad stories. But there are just as many, if not a lot more, really good stories. And sometimes the bad stories cause fear that close off the minds of parents to all the good stories you hear about. And one of the things I love about my job is I get to see and hear a lot of the really good stories and see how things play out very favorably. But one thing I will say, and I don't mean to scare the person who asked this question, a lot of that comes down to advocacy. And for my daughter, if you told me, Derek, when you're gone, you can have one of two things. You can have a really good advocate who knows the system, or you can have a trust with $100,000 in it. I would take the advocate in a heartbeat, because I know if I've got a really good advocate that's really good at advocacy, and when I say advocacy, again, that's a whole nother session, but that's not arguing and yelling, that's advocacy, advocating, knowing how to work and pursue good outcomes for the individual. I would take that advocate every day. Because while that money's great and it's very useful, and it is true that money creates options, and that's absolutely true in the developmental disability system as well, that advocate can get a lot done and you can have a great life for the individual. So I would just encourage you, whoever asked that question, to look for relationships that you can help build for your loved one with special needs, so that they do have advocates around them when you're gone.
Okay, next question. Derek was at another seminar on this subject, and the speaker, if they are the trustee managing a third-party discretionary trust, that when you send them money for that trust, to make sure to put for the benefit of your child's name. Is that only for a pool trust, or is that a big no-no?
If I'm understanding the question correctly, it would be when a trustee is distributing money to the person with the developmental disabilities.
I believe so. Like it maybe as a gift, they should put that on there for the benefit of that person's name.
There's a variety of,
sure.
Yeah, and I think I know what they're getting at. When you create these trusts, there's two ways you can get in trouble. You can get in trouble if the trust says the wrong thing, and that's going to disqualify it. But even once the trust exists, if the trust money is used in the wrong way or an incorrect way, it can cause problems with benefits. And when I say used incorrectly, if that trust comes in and says, I'm going to start replacing what Medicaid pays for with these private funds, or I'm going to start providing all the food, shelter, and clothing, it can cause some problems in those situations. Again, it's all very fact specific. When we talk about titling money and what we call funding, making sure that when I die, all of my assets go into the trust, then it's very important that I write out the name of the trust correctly and that the funds be for the benefit of Megan, but they're going to the trustee. I don't want to just leave the money to Megan. I need to make sure that it's going to the third-party discretionary trust for the benefit of Megan. And so that may also be what they were talking about.
Okay, and I think that was the next question. So a third-party discretionary trust is preferred over a special needs trust?
So again, if the person creating the trust used the term correctly, and it doesn't always happen, if the term was used correctly, and a special needs trust, as referenced in that question, is a first-party special needs trust, then absolutely a third-party discretionary trust should be preferred. Because in a third-party discretionary trust, there's no obligation to pay back the state of Ohio on the person's death. There's more ways the money can be used without getting the person in trouble. Now, if it very well may be, we see it all the time, an attorney drafts a third-party discretionary trust and then they slap special needs trust in the title. And if that's the case, it's just because the attorney used the wrong term. It doesn't mean there's anything wrong with the trust.
Okay, next question. Can you fund a third-party wholly discretionary trust with a brokerage account in the trust's name? This way the money can be invested and can grow versus sitting in a savings account, for example.
Absolutely. A third-party discretionary trust can hold any variety of assets. It can own real estate. It can own investment accounts, stock accounts. Sure. And the last thing you'd want is all your assets to be liquidated and sit in a savings account earning 0.0004% interest. I mean, you can have a portfolio and invest funds within a third-party discretionary trust.
She's commented also, this has been so helpful, and Derek Graham is a very thorough and easy to understand presenter. Great job.
Thank you very much.
Also, I want to remind people to please complete their evaluation, and the link is in the chat. The next question we have is, if real estate passes to my child with this disability so she will have a place to live once my husband and I pass, can a home be given to her through the trust so that she may inherit it without being considered a first party assess that could qualify her from benefits?
Yeah, so a common thing we do, just met with a client earlier this week, and they want to buy a condo for their child with special needs. Now, there's a lot of coordination and planning that needs to be happen. And I will tell you, that works better in some counties than it does others. For very understandable reasons, some county boards are resistant to families buying properties, but they can't stop you per se. So if you wanted to buy real estate and you wanted your loved one to live in that real estate, and then you want them to have that real estate when you're gone, yes, you can leave that real estate in a third-party discretionary trust. And then because it's in a third-party discretionary trust, when that person dies, the asset's not going to be subject to payback or something like that. An individual can own a home, and it's considered an exempt resource for Medicaid eligibility purposes. But if they own the home, then it's subject to payback when they die. So in my case, my wife and I buy a condo, we just deed it over to Megan. Megan can own it, and as long as she lives there, it won't interfere with her eligibility for Medicaid. But when she dies, Medicaid will expect to be paid back out of the equity in that home. Whereas instead, I could put it in a third-party discretionary trust that can own that real estate. Megan can live there. And there's a variety of planning that has to go into that. And if the planning's done correctly, then when Megan dies, that house could be sold or go to her other sisters or nieces or nephews or wherever we've selected.
Okay, can the guardian also be the named trustee?
Yes.
Okay, next question. Is there an annual fee after setting all this up?
No, with us, there's not, no.
Okay. We have another question. We have a lot of good comments to say. Thank you so much. Very informative. Next one is, I have a cousin that I act as an advocate for. We opened him a Medicaid pooled trust a few years back. There's part of me that thinks he could benefit from a stable account. Do you think it would benefit him to have both?
Yes. With a pooled trust, they're not going to put cash directly in his hands. They're going to buy things on his behalf and spend money on his behalf. With a stable account, it gives you a way to put money in that stable account. He can have the debit card and he can actually be the one spending the money. If he has the ability to do that, I think it would be a good thing.
She also put, it was the same question that you just answered. She said, I didn't mean living options. I mean trust-wise.
I guess I don't understand. If you're saying the pooled trust, again, when you say a pooled trust, that could be a first party trust or a third party trust. And
excuse me, Derek, if I may interrupt, those are two different Lisas. And I already responded to,
oh my God, sorry.
to Lisa P. That's okay. Lisa P, please shout out back to me if I did not answer you according to how you asked the question. Otherwise, I think we can move on to the next person. Thanks, guys.
Okay, so the next question is, do we need to register the trust with Ohio State? Do we need an EIN number to open up a trust account in the bank?
All right, so a third-party discretionary trust is going to be an irrevocable trust. And so we do obtain an EIN. EIN means a tax ID number. Again, we only have clients put $10 in that trust because we don't want to trigger any change in your tax status or what you file in terms of taxes. But we do get a tax ID number on behalf of the trust. When you say disclose it to the state, once it's funded and has $10 in it, we have clients where we do it on behalf of clients. We disclose it to the county Jobs and Family Services. Then we ask the Jobs and Family Services to review it and tell us if there's a problem with it. Most send us a letter back saying, we reviewed it, there's no problem with it. There are a few counties that are stubborn and they won't tell us. They'll say, okay, we got it, but we're not reviewing it because it only has $10 in it. And but most will review it and let us know that it works and it's just fine. But either way, it's been disclosed. So no one can ever say, well, we didn't know this trust existed, because you've put them on notice by disclosing it.
And I'm just going to intervene again. This is Amy. Thank you again, Derek, for such a wonderful presentation. You can tell by the questions we could probably talk about this forever. It is 8:32. I just wanted to shout out to Derek and Lori and Wendy. Thank you all for your help, and thank you all who attended tonight. I'm happy to stay on a few more minutes if Derek is agreeable to that. Otherwise, I just wanted to shout out again, please complete the evaluation for us. And don't just share the great things about this presentation, but also give us input on the next transition booster sessions. Derek, I'll leave it up to you at this point. Do you want to take a few more questions?
Yeah, I have to stay a few more minutes because I have to make sure bath time is over before I get home. So
okay.
I'm happy to stay a few more minutes, and that's no problem.
Fair enough. Thank you.
Okay, next question. Does Social Security do a look back if you put money into a stable account? And if so, how long is it?
Once money goes into a stable account, it is cleaned in the eyes of Social Security, and it doesn't count as a resource. Now, when you say do a look back, Medicaid and SSI, I mean, in it, or benefits will look back if, like, let's say Megan, my daughter, has $20,000 in a bank account in her name. And if that happens, that means as a dad, especially in this line of work, I've made a big mistake, because when she's not going to be eligible for Medicaid or SSI. And so she's getting ready to turn 18, and I just transfer that money out of her name and put it in my other daughter's name. Well, when she applies for Medicaid, they are going to look backwards for a period of 5 years, and they're going to see that she just transferred a whole bunch of money out of her name, because they can track a lot of that through Social Security numbers. And it could cause problems. Now, transferring money to a stable account is no problem. As long as I transfer it into the stable account before I apply or receive the benefit, no problem at all with that. And I can apply for, I can have $5,000, put it in a stable account on Tuesday, apply for SSI on Wednesday, and I'm fine.
Good.
Thank you. The next question is, do you currently interface or collaborate with any financial planners with a focus on families with special needs? As a new financial planner with a young boy with special needs, these are the families I'd like help guidance financially, but I don't know of your overlap or your existing collaboration.
So we work with anyone and everyone. I mean, financial planners, I've worked with a lot of them, and I'm happy to work with more. I mean, I tell, individuals when they're doing planning, a lot of times there is a financial component to it. And so if you have a financial planner, bring them to the table, because they can certainly be part of the discussion. For where they get really involved and should be really involved is looking at the mechanics. For somebody that has some assets and they do have retirement accounts and things like that, we can be a little bit strategic to minimize taxes and other things that become a part of every estate plan. And so we're always looking for people to work with. Absolutely.
Okay, great. There's a lot of positive comments and just thanking you, Derek, but there is one more question here. Do you have to fund the trust when you create it? How do you go about making the trust a beneficiary of a life insurance policy?
You don't have to fund the trust when you create it. And for years, I had clients not fund the trust because I was worried about a couple things. Then we got some clarification a few years back, and now I strongly prefer to fund it. Now, when I say fund it, I mean $10 and that's it. I don't want to put more. I don't want to open accounts. I don't want anything else beyond putting $10 in it. And I say that because if that trust starts earning taxable income, it can trigger the requirement that you file a tax return for the trust. And that's a headache. You guys have enough headaches in your life without adding that one to it. In terms of making the trust a beneficiary of life insurance. So again, in my case, I have the third-party discretionary trust for the benefit of Megan Graham. If in my life insurance, if I wanted to make that trust the beneficiary, I would name that trust as the beneficiary. So I would get the beneficiary form. I would check, and every beneficiary form looks different, uses slightly different terms, but I would check that the beneficiary is going to be, and this is where it's very counterintuitive, Derek Graham, trustee of the Megan Graham third-party discretionary trust, dated whatever date it is we signed it. Very counterintuitive because I have to die for that benefit to play out. But at the time I'm making the designation, I am the trustee because I'm still alive. Even though I won't be the trustee at the time I pass away, it'll be Aunt Julie or someone else. So you get a change of beneficiary form and you make the trust the beneficiary through that change of beneficiary form.
Thank you. I think we have one more question. We might have touched on this, but if a third-party trust was set up several years ago, does it have to be disclosed now? We have an EIN number for it. What do you mean by disclosing the trust?
Does it have to be disclosed now? If the trust has assets in it, if it's sitting there in empty trust, I mean, I have a lot of clients I've done work for where we didn't fund the trust and there's no one they need to disclose it to. When you put $10 in it, there's a really good argument you don't have any obligation whatsoever to disclose it. When I say disclose it, if my wife and I pass away and that trust now has $100,000 in it, she certainly needs to disclose that to Jobs and Family Services so that they can review it and say, yes, that is not a countable resource. That was done correctly. It's exempt. Now, the flip side of that is, what if you don't disclose it? Well, there's not a lot they can do. That they'll get mad at you, and it may disrupt benefits for a month or two while they check it out. But it's not going to, as long as the trust is correct, that's what really matters. But there's enough things to do and think about when you pass away for the people that are coming behind you, to where if it's one more thing you can take off their plate and just do now, I would. And also it gives you the peace of mind now of knowing at least that County Jobs and Family Services thinks the trust was done correctly. Because what you don't want is to think it was done correctly and then you pass away and now whoever you've got following behind you finds out, well, paragraph 3 doesn't have the right poison pill clause and therefore it's, doesn't work. And that can be very problematic.
Yeah, I think that's all the questions. Wait, here's one more.
Go ahead.
Oh wait, you already read that one. Do you see any more?
No, I just want to remind people, because there were questions about the recording, and it will be on the Ohio to Family website, and we will probably send it out too. But please complete the evaluations. They're so helpful for us. And Derek, people had amazing things to say, and this was so helpful. So thank you.
Oh, thank you. I love talking
you.
about this stuff. So if there's people watching in other parent groups or something that want to talk more about it, I'm always happy to talk to groups. I enjoy this stuff a lot. So thank you for having me very much.
Thank you, Derek. Thank you so much, everybody. Have a good rest of your night, and hopefully the kids are tucked in and in bed. Wonderful presentation.
Oh, thank you.
Good night, everybody.
All right.
Thank you.
Good night.